we're good?
Yeah, we're good.
Okay, hi everyone. Thanks for being here today. So I was asked to speak about intellectual property, and intellectual property is a very, very broad, subject area. And today I'm going to try and focus on branding and innovation. So primarily trademarks and patents. However, at the end of the talk, I do hope that you know about copyright, what is a copyright, as well as industrial design. So without further ado, this is myself. So a bit about myself, Eddie mentioned. I have a background, a PhD in engineering, a law degree, an intellectual property lawyer for a number of years. And really, my bread and butter has been founding my own technology companies, but also advising companies on market positioning, brand protection, patents, trademarks, and really how do you monetize those assets. So before I can go in to talk about what is, a trademark or a patent, it's very important to understand what is intellectual property and what are intellectual property rights. Because unlike a house or a piece of real estate that you can purchase and market, and then once you purchase the home, you get your papers and you can walk on that ground or that piece of property. Intellectual property is different in that it's intangible, so you can't touch and feel and step on it, okay? And to some people, that makes it hard to conceptualize or even to understand, why would I want to spend money or why would I want to think about an intangible asset? Well, intellectual property can be one of the most valuable assets to your company, whether that be in the form of your brands, trademarks, logos, or patent portfolio, designs. There's a lot of different forms of intellectual property, but basically it brings value to your company, and that's why you need to know about it and pay attention. Ultimately, intellectual property rights, though, are established by governments, okay? So that's also very abstract at first to people, because why am I making an application to the government to get these rights? Well, it's because the whole premise of giving you these rights is based on you have to create a disclosure. So for instance, in the case of a patent or an invention, you have to disclose to the government, to the public, what it is you've invented in order for them to grant you the 20-year rights to monopolize. And that's the exchange that happens. So how is it important to your business? It adds market value. It can be a source through licensing. So for instance, once you have a patent, if it's in a particular area and your competitor wants to use the technology that you've created, this is where a license for the technology can be made. However, without you owning or having the patent, it's very difficult to get such licenses. You can do patent pending. So you've often seen this perhaps on Dragon's Den, even for raising investors. There is some value, or can be some value, even to having patent pending. And once you get the patent, you can stamp it, the patent number, onto the product or good. And there's actually been shown research that consumers, where it says patented technology, are more likely to buy that product, just like trademarks seeing the registered are. And I'm going to get into all of that, when you can use a TM versus a registered. But it really maintains your product or service advantage in the marketplace. So you want to be able to stamp it that this is your trademark, or that you own the patent on this product. So there are different forms of IP, and today I'm not going to get into all of them. I'm primarily focused on trademarks, so branding and patents. However, it's very important that you kind of know each one a little bit. So when you think trademark, oftentimes people get confused and use the word copyright. Okay, so from now on, when you hear the word trademark, think branding. So logos, slogans, okay? We're going to get into trademarks in depth here today, but think branding when it comes to trademarks. When you think patents, think inventions. When you think copyright, think of art or books, okay? Works of art for copyright. Industrial designs, think of mold. So in manufacturing, for instance, you create a mold and then you injection mold it, say, for a plastic shape. So industrial designs, think shape, and layout designs are another form of IP, think chips or microchips. And finally, trade secrets, think keep the genie in the bottle, okay? So those are the six forms of IP, but today I'm focusing on trademarks, okay? One of the quiz questions, which wasn't answered today, but it's in here now, that's good. Must you file for copyright protection? So when I said copyright, what did I say to think of? Books and artwork, okay? It is not necessary to file for copyright protection. So if I was to paint a painting today, a beautiful piece of artwork, or to write a book, just from creating that piece of artwork, I have copyright protection worldwide, and I don't even need to file it with the government. So copyright is one of these forms of IP that a registration is not necessary. I mean, many forms of IP, the registration is not necessary, but it is the only form of protection that is worldwide. So the other forms of IP that we're going to talk about, trademarks and patents, if you want protection in Canada, US, and Australia, for example, you have to apply for government protection or government rights in Canada, US, and Australia. For everything is a separate application for each country, not copyright, okay? So that's moving on from copyright. Now we're gonna delve right into trademarks. So when I said trademarks, I said think of branding, so logos and slogans, okay? So what a trademark does is it is your brand always in association with goods and services. So I'm going to use the example of McDonald's because everyone knows the McDonald's brand. So McDonald's would have trademarks on McDonald's, the word, McDouble, McNuggets, Big Mac, and all of those, they would have to file trademark applications to get a registration with the government. And if McDonald's wanted a trademark protection in 50 countries, which they probably have way more than 50 countries protected because they're operating in so many countries, they would have to apply in each one. And their trademark application would be filed in association with, it's very important, fries, burgers. McDonald's doesn't file their trademarks, for instance, in association with cars or trucks. So in theory, there can be a trucking company that wants to name themselves McDonald's and use that McDonald's trucking, for instance. The governments may be okay with that because they're different marketplaces, one being trucks and one being French fries or food, okay? I get asked a lot, I have a logo, they say, clients say, or I have a slogan. When can I use the R, or what is the TM? So what is the difference between the R and the TM? The R means a registered trademark, meaning the government has given you the grant or the registration that they essentially own that trademark. When you put TM by a trademark, which if any of you currently have brands and slogans, you can start using the TM right away, okay? The TM basically means you are asserting what's called common law rights, meaning I haven't yet registered this trademark or applied for registration, but it's still my trademark, okay? So the TM is what you should use before you get a registration. Okay, now choosing a trademark, okay? So oftentimes, unfortunately, companies choose trademarks that are quote unquote bad, okay? They're just not ideal, and this is the reason why, okay? So a bad trademark is what we call generic, okay? So if you're selling hot dogs and you call your company the Hot Dog Company and you apply to the government for that trademark registration of the Hot Dog Company, the government is likely to say, no, we are not granting you that registration because it's generic. That's not a trademark, basically. And the reason the government says no is because they want to have, they want the ability for other companies to be able to use hot dog company in their branding, okay? The best trademarks are what are called coined, okay? And basically coined is something I put here, the example of Verizon. So Verizon really means, it could mean anything to anyone, okay? It's a made up word, okay? And there's a spectrum here that I've provided on trademarks, okay? So another common, a very common mistake I see companies do is, oh, they're creating, for instance, a new highlighter. And then they're like, let's call it pink highlighter. That is very, very descriptive of exactly what this is. A much better trademark would be, let's call it Sharpie. Sharpie means nothing related to pink highlighter. We as consumers now have come to know Sharpie means highlighter, similar to Kleenex, but over time, these arbitrary, so Sharpie or Apple, right? They build very strong brands and trademarks because they are not descriptive and not generic and even not suggestive, okay? So think of when you're choosing a trademark, this spectrum, that the best trademarks are coined, okay? So besides choosing your trademark, you also need to consider or know that there are different types of trademark registration. So oftentimes companies will have a slogan, such as the slogan "Zoom Zoom," right? That's the Mazda slogan. Or they'll have like a name and a design and a logo, and they say, "I want to file them all. I want to protect them all." Well, each registration, whether it's for the same brand or not, that's an individual application with the government in each country that you want protection, okay? So generally speaking, it is, you know, advisable, but this is not always the case, but usually you would start with filing protection for the word. So for example, McDonald's, and then once you had more resources and your brand was built up and it was justified by the cost, you could seek protection of the logo for the golden arch M, okay? And over time, you would build up your trademark portfolio of assets for your company, of brand assets. Now, would it make sense for a startup to file 100 trademarks on day one? Of course not, okay? As your company spends more and more on marketing, basically promoting your trademark and your brand, you should proportion a little bit that is, you know, reasonable to seek protection for your brand at the same time. So trademarks comes down to, oftentimes the crux is likelihood of confusion, okay? So governments do not want two trademarks in the market and consumers. It's actually meant to protect the consumer, okay? Because they don't want me to go to the store and another highlighter have Sharpie on it because I may think it's just as good a quality as this one. However, it's made in a different place and it's not a Sharpie highlighter, okay? So the likelihood of confusion, there's actually 7 factors, okay? And this is why you should, before you brand and spend a whole bunch of money on creating like logos and slogans, you should really do a trademark search, right, to see what's out there. But where there's likelihood of confusion, the government will say, no, you cannot have this trademark registration. Okay. However, like the example I gave on McDonald's trucking and McDonald's, that may be possible because they exist in different channels of trade. Okay. So to recap the quiz, would a consumer be likely confused that the trademark McDunsum belongs to McDonald's? So this is a real life case. I guess there was a man in Toronto who wanted to open a restaurant called McDunsum, and he wanted to sell dim sum. Okay, and McDonald's sued him for trademark infringement, saying you cannot get a trademark with essentially Mick in it because anything that's Mick and food is infringement. And the court said because McDonald's had filed so many trademarks and had such a large portfolio around the McDouble, not Big Mac doesn't work, but all the Mick food items that they had filed, that caused them to say that the McDimsum guy could not have a registration. And this went all the way up to the Federal Court of Appeal. Are the two trademarks, Assurnica and Assurant, too similar to coexist? And this was a big case in 2018 because a lot of trademark lawyers thought that they actually were too similar, right? However, what the court found is they both, notice how they both have the word basically insurance in there, assurance, right? So the court found that both brands were associated with insurance and they both used insurance in them. So therefore they weren't too dissimilar to coexist. So the courts basically said, if you're choosing trademarks that are descriptive, so they have the descriptive assurance in insurance, then it can coexist in the marketplace. So this is a case where these two brands now are in the marketplace and consumers can get confused which is which. And you don't want that to be your brand. You want your brand to stand alone strong. So even before coming up with a trademark, I believe that companies should really take some time to know the competitive landscape. So sometimes companies just like, oh, I'm gonna name my brand XYZ, and that's it. And then they want to file for a trademark registration. That is not really recommended. So you should know the competitive landscape. Really starts with your brand positioning. So what is your brand voice? What are you trying to convey to the consumer? Who is your ideal customer? Okay, do not use descriptive trademarks. Test the branding perception. So I'm a firm believer that, especially for companies who have not yet brought their product to market with the brands and services, test it with consumers. So, hey consumer, what do you think of the word Sharpie on a highlighter? What does it make you think and feel? Have you ever heard of a competitor with that name? And consider doing a trademark search. All of this, when you're doing your branding, which is what I help companies a lot with, is very critical to avoid trademark infringement or trademark likelihood of confusion problems down the road. Spend the time early on when you have a new brand or service or product that you want to be naming to do this legwork, and it's worth it. Okay, so oftentimes people...
in the interest of time, we got 2 more minutes.
Okay, perfect. So here is what a trademark process looks like, and I can skim through this because basically it's just to let people know that you don't just file with the government and then you get a trademark registration. There is a long, windy process that people can get upset with, but it's a government process that takes time, okay? And I'm ending with patents. However, I am going to be doing another talk in a few weeks or month about patents, okay? So patents is a big, big topic in and of itself. I've provided a resource link there. Before you go down the patent process, it's, it can be $50,000 to $100,000 for a patent in one jurisdiction. So when you think of a patent, you think of this type of document, okay? And you can use Google Documents and do a preliminary patent search yourself. But patent search really protects innovation. It's a 20-year right. It's first to file. So if you have innovation that you do not file and you sell it, or you get on TV, or you make a website and it was very innovative and you gave it away, the government will not give you patent rights. So it's very, very critical to file your patents before disclosing to the public. Okay, and here are the requirements of patentability, but it has to be new, useful, and inventive. And when you make that patent application to the government essentially does a patent search and looks at all of these requirements to see where you fit in. And usually they say, no patent for you, we have some objections. And then there's a process of back and forth to get your patent issue. Okay, so what countries should you file in? And this is my last slide. In what countries you should file in really comes down to your biggest market. So where are you selling and operating your innovation? Okay, so oftentimes Canadian companies seek to file in Canada without understanding that their largest market, because their largest market is the US, the first place and the primary place, if they can only afford one, is to get a US patent, not potentially a Canadian patent, okay? But it all depends. And the last quiz question, which wasn't on the questions at the beginning, but it was, is there such thing as a worldwide patent? And the answer is no. Sometimes I hear companies, oh, I have a worldwide patent. There is no such thing as a worldwide patent. You must file in each country that you seek protection. Okay, and here are some takeaways about trademarks. So choose wisely, consider registering to protect your brand. For patents, you want to file before you have the public disclosure. And trade secrets are the opposite of patents. Trade secrets is when you say, I'm going to try and keep the genie in the bottle inside my organization, but that's usually a bad idea because, as we all know, genies easily can escape from the bottle. So consider patent protection. Okay.
Well, in the interest of time, I think that I'm just closing off with a few remarks. First of all, thank you, Erika, for your time and preparation and presentation today. It's been very educational. We saw some feedback on the chat box that many people echo with that you're a great presenter, very clear cut. We got a refreshing kind of take to the IP world. As a matter of fact, you are the third lawyer 3 weeks in a row. So that was really good that we got a great content from highly regarded people like yourself. So thank you very much, Erika. You guys, can you type a thank you note on the chat box in terms of the applause? That would be great. I'm going to also, in the closing remark, talk about the next few sessions. The next one is I'm going to talk about the leadership aspect, and I'm going to share a book. Many of you might have heard about this book. It's called The 21 Irrefutable Laws of Leadership by John C. Maxwell. I'm dividing this into biteable chunks. So we talk about 3 laws per session. So you don't have to be a leader to come to the class, because all leadership Maxwell is talking about is about influencing other people. So these are the laws that how you could maximize yourself in influencing other people personally and professionally. I'm sure that these highly ethical values will help you to instill great leadership development for yourself. So we welcome you for the next time. The invite will be sharing on your social media over the next 2 days. So please register. Next week we have Sam talk about critical thinking, and Wednesday we have Anthony talk about personal and company tax, and the last session of the month is Valerio from Italy talking about design thinking. So we'll send out those. So for those of you who do not know me, so I'm the partner of OneHub in professional development. I've been associated with the training world for the last 20 years, and I originally started my career in sales and sales management, become sales training and training and development. And my last job was with my role is my global training manager for an engineering company. We teach leadership, we teach selling skill, we teach engagement, problem solving, leadership throughout the many countries. So I welcome you to join us next week or next on Friday. We look forward to have you with us. So thank you very much. Again, thank you, Erika. We'll give you a round of applause. Okay. We'll talk to you on Friday, guys.
Well, thank you everyone.
All right. Thank you, Eddie, Dave, and Erika.
Yeah, thank you.
Looking forward to the next session.
Thank you. Bye.
Bye-bye.
Bye.
Thank you so much.